Hi, good morning, everyone. My name is Stephanie Breen, and I am the school policy staff attorney at SALI. So today I want to review the laws that currently govern college responses to sexual misconduct. I hope that today you will learn how you can support sexual harassment victims while complying with current regulations. And then I also want to discuss some of the anticipated changes to the Title IX regulations. So the applicable laws are Title IX, the Clery Act, and the Maryland Education Article 11601. Title IX is a federal civil rights law that prohibits discrimination on the basis of sex, and it applies to both K-12 schools and to higher education. The Clery Act is actually a federal consumer protection law, and it requires that colleges report how safe their campuses are. And it also imposes certain requirements on schools related to sexual misconduct grievance procedures. And then the Maryland Education Article is, of course, a Maryland state law, and it requires that colleges and universities adopt written policies on sexual assault. The law also imposes a few additional requirements on colleges and universities in Maryland that we'll discuss later on in this training. So the language of the Title IX statute states that schools are not allowed to discriminate on the basis of sex in the context of an educational program or activity, and that Title IX applies to any school that receives federal financial assistance. That is, unless the school is exercising a religious waiver. So if your school has a religious mission, you may be able to apply for a waiver stating that Title IX shouldn't apply because it would violate your school's religious beliefs. Otherwise, Title IX will apply to most colleges and universities, whether or not they're private or public, because most colleges and universities do receive some form of federal financial assistance. So while Title IX is often thought of as the law that requires equal treatment of students in the sports setting, it also governs university responses to sexual harassment, which is what we'll be discussing today. So where are we now and where are we going? So the Department of Education under the Trump administration issued new Title IX regulations following a formal notice and comments process. These regulations were proposed back in 2018. They were finalized in May of 2020, and then they went into effect on August 14th, 2020. And as you may know, this was a really big deal because these regulations completely overhauled how schools have to comply with Title IX. And a lot of schools had to completely rewrite their policies to be in compliance. One of the stated purposes for these revisions was to strengthen the rights of the accused and to provide them with greater due process measures. However, many organizations that represent survivors view these regulations as being favorable to respondents and not being very survivor friendly. The changes made by the 2020 rule significantly weakened protections against sexual harassment. So changes made by the Trump administration included narrowing the definition of sexual harassment, meaning that less types of conduct met that definition. It included adding new due process measures for students accused of misconduct, and included adding more stringent procedures for investigating cases of sexual harassment. So for example, these regulations require live hearings with an opportunity for cross-examination. The Biden administration has stated that they're committed to overturning many of these Trump-era changes to the regulations. Back in July of 2022, the Biden administration proposed new Title IX rules. And these rules are anticipated to make a number of changes, the major ones including finding a better balance between the rights of survivors and the rights of the accused, expanding on protections for LGBTQIA+ students, and making it easier for victims to report sexual harassment by changing the definition of sexual harassment to set a lower standard for what conduct will qualify. The final rules were supposed to be issued in May of this year, and then they were delayed until October, and that deadline has come and passed without a new date being provided. The general expectation is that the final rules will not be released until the end of December at the very earliest, but it's much more likely that they're not going to be released until next year. So for now, the Trump era rule continues to be the law of the land. But there are things that schools can do to comply with the Trump rule while still supporting survivors. And we'll talk about some of those things in this presentation. So it's important to recognize first that not all sexual conduct falls under Title IX. There are several requirements that a complaint of sexual misconduct must meet for Title IX to apply. First, a complainant must be participating in or seeking to participate in the school's educational program or activity. Next, the conduct at issue must meet the definition of sexual harassment. And then the conduct must meet the Title IX jurisdictional requirements, meaning that it happened in a qualifying location. If an incident does not meet one of these requirements and thus is not covered by Title IX, colleges can and should still address that misconduct under a separate non-Title IX sexual misconduct policy. So many schools already operate with two separate policies, a Title IX policy and then an other sexual misconduct policy. And in this manner, schools can ensure that they are complying with Title IX while also being supportive of survivors of all forms of sexual misconduct. So under the 2020 rule, a complainant cannot file a formal Title IX complaint with a school unless they are participating in or attempting to participate in an education program or activity of the school at the time of filing. Schools also have the option of dismissing a formal complaint if at any time during the grievance process, the respondent is no longer enrolled or employed by the school. But schools can choose to support survivors in a number of ways. So first, schools should have clear policies, training, and communications with students that make clear that the school must investigate so long as a complainant files a formal complaint before leaving the school. Schools should further clarify in their policies when a complainant is considered to be participating in an education program or activity. And this can include if the student is taking a leave of absence, if the student has dropped out, but they plan to re-enroll, if the school responds appropriately to the incident, if a student has graduated from one program, but they plan to apply to a different program, or if the student has graduated but plans to participate in alumni activities. Those students can still file complaints and they should be aware that they still have that option. Now, even if a complainant does not meet any of these standards, is not considered to be participating in or attempting to participate in an education program or activity, the school can also still address the harassment under a separate non-Title IX misconduct policy. Additionally, the Title IX coordinator can actually still file a formal complaint on the complainant's behalf under the school's Title IX policy. And finally, if a respondent leaves the school at any point during the grievance process, schools can and should exercise their discretion and choose not to dismiss the complaint under the 2020 rule. So the 2020 regulations changed the definition of what sexual harassment is, narrowing it from its prior definition. Previously, sexual harassment was generally understood to be unwelcome conduct of a sexual nature that affected someone's ability to access their education. The 2020 definitions narrowed the definition of sexual harassment to be one of the three options that I have here on the screen. First, sexual harassment for Title IX purposes can be any individual act that is a sex offense as defined by the Clery Act. And the Clery Act defines sex offense as either sexual assault, which includes rape, fondling, incest, or statutory rape, domestic violence, stalking, or dating violence. Sexual harassment is also an explicit quid pro quo from an employee of the school. This is where an employee conditions some kind of benefit on the receipt of a sexual favor. So for example, a professor might condition a high grade for the semester on a sexual favor. Quid pro quos only count as sexual harassment under Title IX if they're perpetrated by an employee of the school. So a student in a position of power over another student would not qualify. And finally, any non-physical assault that does not fall under the Clery Act can constitute sexual harassment, but it has to be conduct that a reasonable person would deem so severe, pervasive, and objectively offensive that it effectively denies a person equal access to their education. All three of these factors must be met, and it makes it a very high bar. So behaviors that may have qualified under prior regulations may not qualify under the current regulations. For example, a series of microaggressions that occur over a long period of time may be pervasive, but not sufficiently severe. And on the other hand, a single lewd and shocking comment might be sufficiently severe, but not pervasive. The requirement that the conduct deny a person access to education does not mean that the student has to have dropped out of school, failed a class, or something similarly severe. It's enough that a student is just having trouble getting to one class, or is having trouble participating in a single activity, or maybe their GPA is suffering. This element is interpreted more broadly than a student not being able to go to school anymore. And schools can support survivors by making this very clear in their internal policies, their trainings, and their communications to students. Now, under Title IX, schools must dismiss a sexual harassment complaint if the conduct, if true, does not meet this definition of sexual harassment. However, the complaint only needs to be dismissed under Title IX. So just because an incident does not meet the 2020 rules definition of sexual harassment and must be dismissed under Title IX, it does not mean that schools cannot address the misconduct under a separate policy. Schools can and should address other non-Title IX sexual misconduct under separate policies. That separate policy should define sexual harassment more broadly in order to capture more types of sexual misconduct. So for example, an other sexual misconduct policy could cover unwelcome conduct of a sexual nature, including unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. Additionally, schools have the flexibility to define consent, and this affects what conduct will be considered a sexual assault, which we saw on the previous slide is one example of a sex offense that qualifies as sexual harassment under Title IX. So a school's definition of consent should focus on whether there was a clear and voluntary agreement between the parties to engage in sexual conduct. School definitions of consent should make clear that consent is not implied by the fact that a respondent did not use physical force against the complainant. Schools should also make clear that consent is not implied simply because a complainant failed to fight back, because a complainant showed physical symptoms of arousal, or because the complainant had a prior sexual encounter with the respondent. Under the current regulations, sexual misconduct must have occurred within the United States in order to fall under Title IX. So even if conduct occurred during a school-sponsored trip or in a study abroad dorm room owned by the school, that conduct will not be covered by Title IX. Additionally, the conduct must have occurred under an education program or activity. This means that the conduct must have occurred in a location or event controlled or owned by the school. Incidents occurring in an education program or activity include any incidents on campus, any online or digital incident using a school network or platform, any off-campus buildings owned or controlled by an officially recognized student organization, such as a fraternity house, and any off-campus incident that occurs during a school-sponsored program or activity. And finally, any off-campus incident where the school has substantial control over the respondent and the incident. So this means that under Title IX, a student who is assaulted while attending college, but then who drops out with no intention to return, cannot file a Title IX complaint. Another example is if a student is visiting a friend at another college and they are assaulted there, they cannot file a Title IX complaint at that school. Schools must dismiss a sexual harassment complaint if the conduct did not occur in the US or if it occurred outside of an education program. This jurisdictional requirement, unfortunately, will remove the majority of sexual misconduct cases from Title IX because most assaults during college occur off campus. They occur in off-campus housing, at parties, at bars, and at other similar places, but they do not often occur on school grounds. In order to support survivors, schools should make clear to students and employees which off-campus and online contexts it believes that it has substantial control over. For example, a school may have substantial control over some incidents that occur in private off-campus apartments, in private hotel rooms that may grow out of a school-sponsored activity, during students' visits to a professor's home, or while online using a personal device during a school-sponsored activity. If an incident occurs outside of the US or outside of an education program or activity, schools can and should still address it under a separate policy that requires the school to address all reports of sexual harassment, regardless of where the incident occurs. So this would enable survivors to seek recourse if they are subject to sexual harassment, for example, during a school study abroad or a school-sponsored trip that's off campus. Colleges and universities are only required to respond to sexual harassment when they have received actual knowledge of it. Once you know about the harassment, then you must respond to it. For higher education, actual knowledge only exists when reports of sexual harassment are made directly to the Title IX coordinator or to employees with the authority to institute corrective measures. Under prior regulations, reports to any responsible employee of the school were sufficient to create actual knowledge. So students could disclose the harassment to a professor, a coach, an administrator, all of those were sufficient. But now under the current regulations, actual knowledge is much more limited, meaning that schools are not required to take action in as many circumstances. However, a lot of schools have voluntarily chosen to retain the responsible employee standard in their sexual misconduct policies. So Title IX does not prohibit schools from addressing harassment based on notice that does not meet the actual notice standard. Schools can support survivors by going beyond the notice requirements of Title IX. First, schools can and should address any sexual harassment that an employee suspects is occurring, even if that suspicion does not amount to actual knowledge. Schools should also designate a wide range of school officials as having the authority to institute corrective measures to make it easier for students to report. However, schools should also designate some employees as confidential employees to whom students can report without triggering actual knowledge, because sometimes survivors would like to seek the support of a trusted adult without actually engaging in the student misconduct process. And finally, schools should train all employees and volunteers to identify and report sexual harassment to the Title IX coordinator and to respond effectively to those reports, even if those employees' awareness of the misconduct does not constitute actual knowledge for Title IX purposes. The sexual misconduct grievance process is required by Title IX, Cleary, and Maryland law to be prompt. Title IX uses the language prompt, and Maryland law says reasonably prompt. The 2020 regulations to Title IX do not actually define what promptness means. In the past, regulations stated that investigations should be conducted within 60 days, but that's no longer required. And what is considered to be prompt is left up to the schools to decide. Cleary says that schools should provide an expected timeline if there are going to be any delays. Both Title IX and Cleary state that the process can be delayed for good cause. Also, under Title IX, delays must be temporary and limited. Cleary requires that schools notify parties in writing of the reasons for any delay. So if a school does not provide the parties with written reasons for a delay, that is a violation of Cleary. Title IX does provide some examples of what may be considered good cause for temporary delays. These include if either party is absent, if there is any law enforcement activity happening at the same time, or if there is a need for language assistance. However, a school's grievance process is not dependent on a concurrent police investigation. So if police activity extends beyond a temporary delay, then the school must continue its own investigation independently. Title IX does not overlap with the criminal justice system, and it is possible to conduct both types of activity at the same time. Law enforcement activity and especially criminal cases can take a very long time. Title IX cases are supposed to be resolved promptly because the condition of being a student is temporary. And when these cases take as long as 10 months, that means that they are ongoing for almost a quarter of an undergraduate student's time in college. These investigations need to be resolved more quickly than what it takes for a criminal case to make its way through the criminal justice system. Additionally, schools should already have a plan for language assistance. So again, while these things may constitute good cause under Title IX, they are not definitively good cause, and it's going to be a fact-specific and situation-specific determination. In order to support survivors, schools can and should require that their grievance processes conclude within 60 days or less, as long as the parties have at least 10 days to review and respond to the evidence, and at least 10 days to review and respond to the investigative report. Schools should never delay conducting their own investigation simply because the police are also investigating. Law enforcement investigations, as I said, can take a very long time, and waiting for that process to be resolved would unnecessarily delay a survivor's ability to seek a resolution that will aid them as a student while still in school. And finally, schools should have a plan in place for language assistance ahead of time. The Title IX office should be coordinating with other offices that provide language assistance and disability accommodations so that students with those needs are not unfairly burdened or delayed in receiving supportive measures or when participating in an investigation. So a complainant who reports to their school does not have to go through a formal investigation or have a hearing and adjudication. They may report just to receive supportive measures. Schools are required to talk to complainants about supportive measures under both Title IX and under the Maryland Education article. Under Title IX, supportive measures are no-cost measures designed to restore equal access to education or restore campus safety. The Title IX coordinator must reach out to the complainant and offer them supportive measures upon the school's receipt of actual knowledge. They must be non-punitive and not be overly burdensome to the respondent until there has been an actual adjudication and a final finding against the respondent. However, this doesn't mean that there can't be any effect on the respondent. Supportive measures are allowed to be burdensome, they just cannot be overly burdensome. And again, this is a fact-specific inquiry. Title IX doesn't require any specific accommodations or specific supportive measures be offered, but it does give specific examples, such as academic accommodations, no contact orders, counseling referrals, and similar things. Depending on the facts of the case, schools may be allowed to remove a respondent from participation in sports, so long as it's not punitive. The Maryland Education article imposes more specific measures than just requiring a school to have a conversation with a complainant about supportive measures. If the conduct committed by a respondent constitutes a crime, Maryland law requires that schools tell the victim that they have the right to file criminal charges and that the school assist the complainant in filing those charges. Maryland also requires that schools designate the nearest safe hospital to transport complainants to that safe hospital for medical treatment and a medical exam. And a safe hospital is a hospital that conducts sexual assault forensic exams. Maryland law requires that schools either offer on-campus counseling, or if a school does not have on-campus resources, that schools refer complainants to a local rape crisis center. And finally, if feasible and upon request by the complainant, schools have to help complainants transfer their classes or their housing. Upon request does mean that schools only have to do this if a complainant asks. Though we advise that schools make complainants aware that this is an option that they have. Neither Title IX nor Maryland law requires that respondents receive supportive measures in the same way that complainants must receive them. However, there is nothing in either law that states that schools cannot offer respondent supportive measures, and most do offer them those. Under Title IX, supportive measures are required even if the complainant or the respondent is no longer at the school, so long as the conduct meets the 2020 rules definition of sexual harassment, it occurred within the United States, and it occurred within an education program or activity. Schools should clarify in their policies and communications to students examples of permitted supportive measures. Often, students do not know what options are available to support them. Examples of supportive measures that are allowed under the 2020 rule are things like having an educational conversation with a respondent about their behavior, its impact on the complainant, and the school's sexual harassment policies, changing a respondent's seat, class, housing, or dining hall assignment, issuing a one-way no contact order against a respondent, which means prohibiting the respondent from directly communicating with a complainant, and placing an employee or a student employee on paid administrative leave. If Title IX does not apply to an incident because it does not fall under the 2020 rules definition of sexual harassment, if it occurred outside of an education program or outside of the United States, schools can and should still provide supportive measures to all complainants under a separate non-Title IX sexual misconduct policy in order to provide additional support to survivors. Once a school has actual knowledge of sexual harassment, it has the option to remove a respondent prior to an investigation or adjudication, but only if it's an emergency situation. So there must be an immediate threat to the physical health and safety of a student. The assessment of this threat must be individualized, so schools cannot have blanket removal policies. For example, schools are not permitted to have a blanket policy that all assaults with a weapon are considered to be an immediate threat to the physical health and safety of students. Each specific incident must be subject to an individualized assessment for a threat. If a school does conduct such an assessment and does determine that a respondent is a threat, then the school must provide the respondent with notice and an opportunity to challenge the determination. Schools should also thoroughly document the reasons why they have found a respondent to be a threat to health and safety. This rule does not apply to employees. Employees who are accused of sexual harassment may be placed on administrative leave during the investigation or the formal grievance procedure. Schools may only investigate claims of sexual harassment upon receipt of a formal complaint that is in writing and signed. The formal complaint can be signed by either the complainant or by the Title IX coordinator. This means that a school may conduct an investigation without the consent of the complainant. However, in practice, I find that this rarely happens, and usually schools only initiate investigations without the consent of a complainant if there's a severe danger to the community or if the school is very worried about the perpetrator. And we would advise that schools do this sparingly in order to respect the wishes of a survivor of harassment. However, again, Title IX cannot be used to investigate a formal complaint if the complainant is not actively participating in or seeking to participate in the education program or activity. Schools can and should have a separate misconduct policy that enables them to investigate, even where the complainant is not actively seeking to participate in the educational activity any longer. So far, I have already touched on some situations where schools are required to dismiss sexual harassment complaints under Title IX. There are also certain situations where schools are permitted but not required to dismiss complaints. So again, schools must dismiss sexual harassment complaints only under Title IX if they do not meet the definition of sexual harassment, if the conduct occurred outside of an education program or activity, or if the conduct did not occur in the United States. Schools may dismiss sexual harassment complaints under Title IX if the complainant requests it, if the respondent withdraws from the school or quits the school, or if circumstances prevent the school from being able to gather sufficient evidence. The inability to gather sufficient evidence does not mean that the complainant was unable to meet their burden, but rather this refers to circumstances such as key witnesses being unavailable. And again, even if sexual misconduct must be dismissed under Title IX, schools can and should proceed to investigate the conduct under their other sexual misconduct policy. So I want to quickly touch on the Clery Act. Clery is a consumer protection law that applies only to higher education. The Clery Act requires institutions to compile and report crime statistics in order to let the community know how safe their campus is. This report is not only for sex-based crimes, but it's actually for other crimes as well, like burglary or arson. Schools are required under this law to publish a report stating how many crimes have occurred within the Clery geography, which means any crimes that have physically occurred on the school's campus or in their buildings. The origins of this law are that it was lobbied for by the parents of Jean Clery, who sadly was raped and murdered on her college campus. After the attack, her parents learned that there had been a series of violent incidents on campus prior to the attack, and they thought that perhaps if they had known about the violence on campus beforehand, it wouldn't have happened. So the purpose of Clery is to keep students informed so that they can make informed decisions about their safety. Clery also has a set of amendments that we call the VAWA amendments. They were added in 2013 with the passage of the Violence Against Women Reauthorization Act. And these provisions state that survivors of sexual assault, domestic violence, dating violence, and stalking have additional rights. Unlike the crime reporting provisions of Clery, which only require universities to report on crimes that occur on their campus, the VAWA provisions are not geographically bound, and a survivor's rights under Clery will apply regardless of where the assault occurred. It's important for colleges to be aware of Clery generally because it can provide rights to survivors even when Title IX does not apply. The VAWA provisions impose requirements on what school misconduct policies must look like when they are applied to a VAWA crime. So even when misconduct does not fall under Title IX, if it constitutes a VAWA crime, the school misconduct policy must comply with the VAWA provisions of Clery, and I will discuss later on some of those specific requirements. So unlike Title IX, which does create a private right of action, Clery does not. So students cannot sue a school under Clery. However, they can file a complaint with the Department of Education. And the penalty for a violation of Clery is fines, which can go up to $59,000 per infraction. This applies both to the crime reporting provisions as well as to the VAWA amendments. Threatening a school with a Clery Act complaint is something that we have seen students do in the past, and so it's something to be very careful of. So after receiving supportive measures, a complainant may decide that they want to go forward with the formal investigation process. The investigation process can also be initiated by the school without any request by the complainant. So for example, the school may decide to do an investigation based on concerning reports from a complainant's peers, from professors, or from other concerned members in the campus community. However, it's very rare. We don't often see schools doing this. And often when a complainant expresses that they don't want to go forward with an investigation and that they want to keep the complaint anonymous, schools will allow that, and we find that this is best practice. The VAWA amendments to Clery require that any formal process or meeting that's used to investigate and adjudicate a sexual misconduct claim be prompt, fair, and impartial at every stage. Clery also states that the process must be transparent to both parties. This means that schools must follow their own stated policies. Schools are allowed to put things in their policies that are not required by law to be included, but once that item is included, schools must abide by it. And this is because both students have the right to know what to expect throughout every stage of the process and what their rights are at their school. Under Title IX, schools are required to provide both parties with notice of the allegations. The respondent must receive notice of the identity of their accuser and of the date, time, and location where the alleged conduct took place. Both parties are required to be notified of the right to an advisor of their choice. Both parties are also to be told that there is a prohibition against making false statements. And both parties must be told that there is a presumption that the respondent is not responsible for the alleged conduct until a final determination has been made. This is reminiscent of the idea of innocent until proven guilty, although these hearings are not supposed to be like the legal process or a criminal process. Schools should make it clear in their policies that the presumption that the respondent is not responsible until a final finding is made does not amount to a presumption that the complainant is lying. Maryland law requires more in terms of notice than Title IX does. So under the education article provision, both parties are entitled to written notice of the alleged violation, including a range of potential sanctions. Clery also requires schools to provide a range of potential sanctions. So this can include things ranging from the respondent writing an essay about what they did or giving an apology to suspension or expulsion from the school. It's important for advocates to understand that there is a huge range of potential sanctions. And it's important for schools to recognize that there are a lot of options that are available, and that advocates may come forward with creative kinds of solutions that the school might not have heard of before, but those solutions may still be permitted. So schools are not just limited to expelling or not expelling a respondent. There's a lot of other options in between that are permitted to be considered. Schools must notify both parties not only of the right to have an advocate of their choice, but also that they have the right to a trained advocate or attorney, such as those on the Maryland Higher Education Commission's list. Under Maryland law, both parties also have the right to have a support person. So Maryland law says that both parties have the right to have no more than 2 people with them at anything where their physical or virtual presence is required. This means that at any meeting or interview and at the final hearing, each party can have their advisor as well as a support person present. And the support person can be anyone. They can be a family member, a friend, someone else who works in the school's office. It can be anyone. Federal law does not say anything about support persons. The only thing that the federal law says is that any restrictions that a school places must be placed equally on both parties. But under Maryland law, it can be no more than 2 people at each meeting. Under Maryland law, which not only says that parties have the right to have an attorney or advocate present, but the parties have the right to have an attorney or advocate free of charge. So this is where the Maryland Higher Education Commission, or MHEC, comes in. So schools are required to provide both complainants and respondents with MHEC's list of attorneys who are available to students to advise them during the grievance process at no cost. And you can find this list on MHEC's website. If you just Google MHEC attorney list, Google will take you right to it. Both Clery and Title IX state that the advisor the student chooses must be their advisor of choice. So schools cannot put any limitations on a student's choice of advisor. The advisor could be an attorney, or it could be a parent, a teammate, or a sorority sister. An advisor could be someone who's not qualified to give advice about these kinds of proceedings. They can even be witnesses in the actual case. Schools can put restrictions on support people, however. Those restrictions just have to apply equally to both parties. So schools can and often do state that support people cannot also be witnesses in the case. There is an informal resolution or mediation mechanism available under the law that is important to understand. The Title IX regulations state that schools may offer mediation except in cases between a student and an employee. So mediation cannot be offered in cases where the respondent is a professor or someone else who works for the school. Otherwise, mediation is permitted under Title IX so long as both parties consent in writing. Mediation can never be required, and either party may withdraw from the mediation process at any time. Maryland law imposes some limits on mediation. So Maryland law states that mediation should be offered except in cases dealing with sexual assault and sexual coercion. If mediation is offered, it can only be offered after a complainant requests it. All parties must agree to engage in mediation, and either party may withdraw at any time. Additionally, Maryland law requires that the school have staff who are specifically trained to conduct mediations. So we have found that some schools in Maryland have taken this part of the law to mean that they are not allowed to offer any sort of informal resolution. Informal resolution is where parties work out a private agreement that spells out the terms moving forward. So for example, they may agree that one party will drop out or transfer, or they may come to terms that limit the parties' interactions on campus. And this can lead to really good results for both of the parties when they work out their issues in this way. And although there is this belief that schools are not allowed to permit informal resolution, that's actually not true. So schools may permit informal resolution, they just are not permitted to facilitate that informal resolution themselves. The reason for this is because sexual assault and sexual harassment is conduct that is characterized by a power imbalance. So the conduct is about power and control, and you can't really mediate between parties when there's a power imbalance. So if both parties have an attorney and neither wants to go through the formal process, even if it's already started, the best practice for schools is to permit those parties to engage in that process, because then there's no longer a power imbalance when they're both represented. During a Title IX investigation, schools are generally not allowed to restrict parties' ability to build their own case. Schools should permit both parties to investigate, to gather their own evidence, and to talk to potential witnesses. This is very different from what the regulation said prior to 2020. So previously, schools were permitted to issue gag orders, saying that the parties were not allowed to talk about the case and that they could not investigate or talk to witnesses. And sometimes the parties would even be reprimanded for trying to speak to witnesses on their client's behalf. But now under the 2020 regulations, that rule has gone away, and schools may not limit parties from discussing their case. The only limitation is that parties may not access, consider, disclose, or otherwise use a party's medical or mental health records without that subject's voluntary and written consent. The investigation should include interviews of both parties and interviews of any witnesses. Both sides are permitted to provide the school with witnesses for the school to consider and to interview. Schools should permit both sides to review transcripts of the interviews and to correct them if there are any mistakes. After the investigation process has concluded and all of the evidence has been gathered, schools must compile an investigative report. That report must summarize all of the evidence that has anything to do with the case. And at this stage of the process, when it's the initial investigative report, it does not matter if the evidence is relevant or not. And it also does not matter if the school intends to rely on that evidence in making its decision. So other than mental health and medical information, there's essentially nothing that can be taken out of the first round of reports. All of the evidence that is related to the case has to be included in the initial investigative report. Once it's compiled, the school must make the initial report available to both parties and to the parties' advisors. Schools are required to send the report directly to the advisors. And this is the only time in the process that schools are actually required to communicate directly with the parties' advisors as well as with each party. However, I advise schools to communicate more frequently with the parties' advisors than what is required, because this enables the advisors to be more promptly up to date and to provide better advice to the parties. Once the report is out, each side gets at least 10 days to submit a response to the report. In their responses, parties can make comments about details that are incorrect or missing from the report. After party responses are received, schools should consider their comments and then issue a second round of reports. This process can take a significant amount of time, and sometimes it might require that the school conduct additional investigation to gather more needed information. The second report that is issued should summarize only the evidence that the school determines is relevant to the case. And at this point, the school may remove things from the report that it knows the final decision maker will not be allowed to rely on in making a determination. And then again, both parties will get at least 10 days to comment on the second round of reports. So this means that there will probably be almost a month in between the release of the first report and the finalization of the second report. And then schools are not permitted to hold the hearing less than 10 days after the second report is released. Both sides must be provided with time to prepare for the hearing. I want to just briefly talk about FERPA, which, as you already know, it's a federal law that protects students' privacy. It applies both to K through 12 schools and also to higher education, and it states that schools cannot disclose educational records without students' or parents' consent. However, schools should know that Title IX trumps FERPA, and parties should not be restricted in their ability to have equal access to the evidence that is related to their case. So once the investigation's over and rounds of reports and comments are finished, the adjudication phase begins. Under the 2020 regulations, colleges and universities are required to conduct a live hearing at which there is cross-examination. Prior to the 2020 regulations, a live hearing was not required. Before, the parties could submit questions, and then a neutral third party would ask the opposing party those questions. But now schools are required to conduct live hearings during which both parties can see and hear each other in real time. This doesn't mean that schools have to hold the hearings in person, though. The hearings can be conducted virtually. Both parties have the right to cross-examine the opposing party and any witnesses, and cross-examination is allowed to be conducted by the party's advisors. If either student does not have an advisor by the time they reach the hearing stage, one must be provided to them free of charge. Maryland law states that not only are schools allowed to provide a virtual option, but they are actually required to provide a virtual option to the parties so that they don't have to be in the physical presence of one another. And either party can request a virtual hearing. The fact finder, which is the person who runs the hearing and makes the final decision, cannot be the same person who conducted the investigation, and they cannot be the Title IX coordinator. In the past, investigators could make recommended findings, and the Title IX coordinator could make the final decision. Under the 2020 regulations, an independent decision maker must be brought in. All of that decision maker's information has to come from what is in the reports and then what happens at the hearing. The hearing examiner, as well as the investigator or anyone else involved with the process, can be removed for bias. That means that schools must inform the parties of who the hearing examiner is going to be and give them the opportunity to challenge that person for bias. Bias usually means that there is some kind of pre-existing relationship between the decision maker and one of the parties or the witnesses. During cross-examination, advisors must follow a process where they ask a question and then they pause to allow the decision maker to decide whether or not the question is relevant. The decision maker will then tell the witness whether or not they can answer the question. Under Title IX, the only evidentiary standard is relevance. And the only reason that a piece of evidence can be excluded is because it's not relevant. There are no other evidentiary rules. So for example, there is no rule against hearsay. Any other evidentiary rules are going to be completely up to the school to decide to implement. So as I said previously, Title IX does not define relevance, and it's really up to the schools to decide. However, there is an exception when it comes to sexual history. Under Title IX, the sexual history of a complainant is by definition not relevant. Any questions or evidence about a complainant's sexual history are not relevant unless they prove that someone other than the respondent committed the conduct, or if it concerns specific incidents between the parties and is offered to prove consent. These are two very narrow exceptions, and it's important to recognize that Title IX only prohibits evidence of a complainant's sexual history. Prior to the release of Title IX, under Maryland law, schools could not consider the sexual history of either student, so either the complainant or the respondent, except to prove the source of the injury, to prove prior sexual misconduct, to support a claim that a student has an ulterior motive, or to impeach a student's credibility after they put their own sexual history at issue. But under the current regulations, the exceptions under Maryland law only apply to respondents. So they still have some protections, but not much. So there's clearly a conflict here right now between federal law and Maryland law. And of course, the federal law is going to trump the Maryland law. Our attorneys at SALI have seen situations where, for example, a complainant put their own sexual history at issue, and it turned out that what they said was not true. And the respondent was not permitted to present evidence that the complainant was lying to impeach their credibility. Schools can support survivors and support both students by clarifying what evidence is not relevant, and can also go beyond the protections of Title IX by stating that additional harmful evidence or misleading evidence is not relevant. So for example, schools can state that the clothing or makeup that a survivor was wearing at the time of the incident, or evidence that implies sexual activity such as pregnancy, the use of birth control, or STIs, that none of that evidence is relevant. It's written into the 2020 regulations that if a party or witness does not submit to cross-examination at the live hearing, then the decision maker cannot consider any statement that the party has ever made and cannot draw an adverse inference from the party or witness's refusal to testify. This rule has had a huge impact on hearings over the last few years. So for example, if a respondent confessed to committing the alleged conduct, but then refused to submit to cross-examination at the hearing, then their confession could not be used. Police records couldn't be used unless the officer actually went to the hearing and submitted to cross. And it was the same for safe exam results, so the sexual assault forensic exams. And this caused a lot of evidentiary issues, especially because there is no subpoena power to make people go to these hearings to testify. So in the case of Victim Rights Law Center et al. Versus Devos et al., which was a Massachusetts District Court case, the judge found that cross-examination requirement was a violation of the Administrative Procedures Act. Because it's been overturned, schools are no longer required to disregard statements made by parties who have not submitted to cross-examination. The Department of Education has issued a letter that said they will no longer enforce that portion of the policy. So students cannot file complaints about it and they cannot sue over it. However, there is nothing that says that schools can't still have the cross-examination rules in their policies. But schools can and should remove this from their policies in order to better support survivors and to avoid adverse effects on the proceedings. Under federal law, Clery requires schools to state what standard of proof governs sexual misconduct hearings. Title IX states that schools are permitted to choose between clear and convincing or the preponderance of the evidence. Whichever standard a school chooses, they must use the same standard for all Title IX complaints, including those against or between faculty members. The standard for allegations between students must be the same as the standard used for claims involving faculty members. However, federal law essentially permits schools to single out sexual harassment complaints and to treat them differently from every other type of misconduct complaint. So sexual harassment cases can be subject to heightened scrutiny. However, Maryland law provides protection against this and states that schools must apply the same standard to sexual harassment cases as to all other similar types of misconduct cases that involve discrimination or harm to another person. Schools can support survivors by choosing to use the preponderance of the evidence standard. This is the same standard that's used by courts in all civil rights cases, and it is the only standard of proof that treats both sides equally. Once a hearing is over, Title IX requires that the decision maker issue written findings. These findings tend to be very long because they must include the allegations, a description of all the steps that were taken from the complaint through the final determination, what evidence was considered, the findings of facts that support the determination, the conclusion regarding the application of the code of conduct to the facts, and the rationale for each finding and any sanctions or remedies imposed. Clery also requires that schools give a rationale for their findings. Decision makers should not simply be issuing findings that state that the respondent is responsible because it was shown by a preponderance of the evidence that they committed sexual harassment. Decision makers have to explain how they reached that conclusion. The parties also have a right to know what remedies and sanctions were imposed and what the appeals process would look like. So under both Title IX and Maryland law, both parties have the right to appeal. Parties not only have the right to appeal the final determination of responsible or not responsible, but under Maryland law, they have the right to appeal the severity of the sanction. So for example, if someone's found responsible and the sanction is to write an essay, the complainant could appeal and argue that that's not severe enough. If the respondent is found responsible and is expelled, they may appeal and argue that they should not be found responsible, and then alternatively, that if they are still found responsible, that the sanction is too severe. Both sides must be provided equal rights to appeal. Under both Maryland and federal law, whatever bases a school offers for appeal have to apply equally to both sides. Under federal law, schools have to allow appeals based on procedural irregularity, new evidence that was not previously available, or a conflict of interest or bias by someone at the school who was involved in the process. Parties have 10 days to appeal the final decision, and both sides have 10 days to respond to the opposing party. Any sanctions imposed by the school should not go into effect until either any appeal is decided or until the appeals period expires. So if 10 days goes by and no one files an appeal, the sanction then goes into effect. If someone does file an appeal, the sanction is stayed until the school is able to figure out the appeal. The final topic is retaliation. So all three of the laws that I have talked about today, which is Title IX, Clery, and the Maryland Education article, they all three prohibit retaliation. Schools are not allowed to retaliate against anyone for filing a complaint or for participating in the investigation process. This means that schools cannot discipline a complainant for engaging in collateral conduct during a reported incident of sexual harassment. Collateral conduct is conduct that the student was engaging in that could independently subject the student to misconduct proceedings. So this includes things like underage drinking or maybe violating a COVID policy. The exception to this under Title IX is if a school has a zero tolerance policy, where the school always punishes that collateral conduct, even if it occurs during a student's victimization. Generally, punishing survivors for collateral conduct that they have admitted to while reporting sexual misconduct will deter the reporting of sexual misconduct. Schools are also required to have a response if someone else at the school appears to be engaging in retaliation. For example, if a complainant's friends all start to harass the respondent, following them around and calling them names, that could constitute retaliation, and schools are required to look into that conduct. However, Title IX does specify that it is not retaliation to charge a party with making a false report, provided that the allegation is not based solely on the outcome of the case. So essentially, as long as the person making the charge has some specific reason for why the report was false, and not just that the respondent was found not responsible, then the charge is not going to be considered retaliation under Title IX. I advise schools not to do this unless they have a very strong basis for doing so, because it would have a chilling effect on plaintiffs who want to engage with this process. Schools also should not discipline a complainant for lying solely because the respondent was ultimately found to be not responsible. Schools can and should inform all parties that retaliation is prohibited and make clear in their policies and communications what does and does not constitute retaliation. Schools can and should adopt policies that prohibit punishing a complainant for collateral conduct during an incident, regardless of whether the school has a zero tolerance policy, in order not to deter survivors from coming forward. Schools should prohibit punishing a complainant for missing class if they do so to avoid their harasser after an incident. Schools should also prohibit pressuring or forcing a complainant to take time off, to transfer to another school, or to enroll in an alternative education program after they've reported an incident. And finally, schools should prohibit punishing a person for unintentionally misstating details or for misstating immaterial details during a grievance process. Sexual harassment is a very traumatizing incident for most survivors, and it can be very difficult for a survivor to recall the details of what happened or to provide those details in a chronological order. So it's very important for schools to have trauma-informed policies that recognize the impact of trauma on survivors and provide that needed support. And that concludes the presentation. If anyone has any questions, please feel free to send me an email and I'd be happy to get back to you. I'm also always available for technical assistance. If a school wishes to refer someone to SALI, we help survivors across Maryland with a range of legal issues. So not just schools issues, but if survivors need to seek a peace or protective order, if they have family law issues, if they need representation in a criminal case for crime victims' rights representation, we represent survivors in employment discrimination and a lot more. So thank you very much.
Thank you for that presentation. So I'd like to direct everyone's attention to the chat. I put the evaluation link there. We strongly appreciate any feedback as we are constantly striving to improve our training programs. Also, as a reminder, if you're seeking a certificate of attendance, you'll need to fill out the evaluation form, and you can expect to receive your certificate within 3 to 4 weeks. Also, you'll be receiving an email with the link to this recording, as well as the PowerPoint notes and the evaluation link in case you miss it in the chat. And again, I'll include Stephanie's email address in the email, so that way if you have any follow-up questions, you could get that to her. Thank you so much.